never knew my former boss loved me enough to leave her children to me.
Or I know them.
Oh, no. Good call. Good call. All right, so we're going to go through super fast. Now you have your state court order, right? You have your predicate order. It has lots of detailed facts in it. It maintains jurisdiction. You've done such an excellent job in the state court part, or your partner volunteer attorney has. Now what? So this is very nuts and bolts, sort of how to file for special immigrant juvenile status and then permanent residency with U.S. Citizenship and Immigration Services. All forms that you're going to need in your immigration case, whether it's your asylum application or it's your special immigrant juvenile status petition, your permanent residency application, all of those are available for free on uscis.gov. Don't do uscis.com. It is a very bad website that gets you to pay for forms that are free. So uscis.gov, and make sure that you're using the most current version. They did just update them in December, so don't use like an old sample that you've done on a previous case, or have a friend that did a previous case. Make sure you're using the current one. Here are the forms that you need. You just need the I-360 petition for special immigrant juvenile status. You need a G-28, which is your notice of entry as the attorney. You might write a very brief cover letter just saying, here's what's attached here. You need a copy of the birth certificate along with a certified translation. Somebody sent in a question, where do you get a certified translation? Send it over to Remain. We can help you get it translated if you don't have anyone in your firm or in your life that can do it. It doesn't have to be a court certified interpretation or translation or anything. It just needs to be somebody that can write down on a paper, I certify that I am bilingual in English and Spanish and that this is an accurate translation of the attached birth certificate signed so-and-so translator, not even notarized or anything. So if you have anyone that can do it, please do it. If not, send it over to Remain and we'll get it done for you. Translations are, especially of birth certificates, are pretty easy for us to get done as opposed to interpretation at an interview or things like that. And then you need a copy of your state court order. That's it. Please do not submit more than that. If you look on that uscis.gov site, it will tell you also submit an affidavit from the child talking about their abuse, abandonment, neglect, and all of the state court documents and blah, blah, blah. They wish. No. The only thing that you want to submit is the state court order and those forms. There's no fee, and please don't submit anything else. USCIS is not the one under the statute, right, who's supposed to be looking into, was this child abused, abandoned, or neglected? Is it in this child's best interest to be returned to Honduras? That was already decided in the state court, right? And so you don't want to be giving over a lot of extra stuff to USCIS for them to dig behind that order. The only caveat to that is if you don't have a good order and it just has the statutory language, then you're going to need to hand over more stuff. But you guys are all going to have excellent orders with lots of detailed facts, so that won't be an issue. By statute, under that Trafficking Victims Protection Reauthorization Act, the I-360 petition for special immigrant juvenile status must be decided within 180 days. So please flag that on your calendar for when you're approaching the 180-day mark. They're generally pretty good about adjudicating it within that time, but if you're approaching that deadline and you haven't seen a decision, there's an email address here for the National Benefit Center that you can email them and say, hey, as you know, this needs to be decided within 180 days. Please send us our decision. The term special immigrant juvenile status is kind of a misnomer. Special immigrant juvenile status is not actually a status. If you are approved, if your I-360 petition for special immigrant juvenile status is approved, you don't actually have lawful status in the U.S. What you have is that you were deemed paroled into the U.S., which allows you to move on to the next step of applying for your green card. Only people who were paroled or admitted lawfully into the United States have the right to then move on and apply for a green card. So what SIJS does is say, now we deem you paroled, you may move on to the next step to apply for your green card. So kids are in still a bit of a precarious situation if all that you have is your I-360 approval, and it's important to understand that they still do not have lawful status in the U.S. The next step then, if you get your special immigrant juvenile status approved, is to move on and apply for a green card or permanent residency in the U.S. Here are the forms that you need: the I-45 application for adjustment of status. Oh, I'm sorry, it's another slide that I have. I hope I have. Oh, maybe in a minute I have one that lists out all the forms that you guys need. But before you say, okay, now I have my I-360 approved, I'm going to go ahead and move on and send in this I-45 application for the green card, hold on. You need to know that this child has a visa immediately available. And when I say visa, what I mean is a green card. What I mean is a permanent residency number, basically, available. It used to be that it was automatic, basically, that you could move on from the I-360 to, move on from the special immigrant juvenile status to the permanent residency. Now you need to stop and check, can I move on, or when can I move on? So the way that you do that, here is the first website that you're going to go to, the Visa Bulletin. You're going to check under employment-based fourth preference category, which is where SIJS falls under. And you're going to check and see, is my client's priority date current? The priority date, or now what they call is the final action date, just to be even more confusing, is the date that your I-360 petition was receipted. Not the date that you mailed it, not the date that it was approved. The date that it was receipted by immigration is your priority date or your final action date. Okay? So you filed your client's I-360. Your client is from Honduras. You filed it on July 15th of 2016. Let's pretend. Okay? Go back to a happier time, July 2016. Now that's been approved. Can you now submit your I-45 application? Well, let's go to that first website. Here is the Visa Bulletin, okay, for whatever month you're in. Right now it looks, I pulled up March 2017. You're in the employment-based chart here. You're going down to the fourth preference, so see that 4 down there, and you're scrolling over to Honduras. See in the third, there it says El Salvador, Guatemala, Honduras. That says July 15th, 2015. It has said that for several months. It will say that for several months. It's not moving forward and likely won't move forward until October of 2017, we assume. Check that. Is your client's priority date current? If their priority date is July of 2016, this says they're processing applications that were filed in July of 2015. No, that's a year apart, right? Doesn't necessarily mean that it'll be a year wait. It could be in October 2017. It jumps forward a year. We really don't know, but you want to just be checking it and see, when does your client's priority date show up on there, that it's their turn to move on, basically, to the next step of applying for permanent residency. Now, just as of a couple months ago, immigration made this even more complicated. Ready? So this is the first chart, which is called the final action dates chart. You're checking for your client's I-360. No, it's not current. But you don't stop your inquiry. You say, well, will they accept it anyway, even though it's not current? Is the filing dates chart current? Oh, man. You can't see fourth. Sorry. But if you could, here's the next chart, the filing dates chart. If you were to go down to fourth, which has disappeared off our screen, you'll see it looks like the first. C, 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 C. C means current. C means we're accepting it. C means even though your client's priority date is not current, go ahead and file it anyway. Why would you want to do that? Because they can get a work permit while it pens. Very important for our 16, 17-year-olds. Also very important for our young children who need some form of government ID. But hold on, even if it says current, can you use this chart, or do you have to use the first chart? Which chart do we use? Now, there's another website that you go to, which is right here. USCIS.visabulletin.gov/visa bulletin info. You'll click on that and it'll tell you which chart can you use this month. We will help walk you through this. Okay, I know this is really getting into the weeds, but this is what we have to do. So this one says For employment-based preference filings, remember we're under employment-based fourth preference, so that's SIJS, right? For employment-based preference filings, you must use the final action dates chart. Wah, wah. You have to use the first one. Your priority date is not current. You cannot file. Sometimes that has said you must use the filing dates chart.